It is day 5 of the Delphi murders trial. Today, we heard from a witness on the scene, the doctor who performed the autopsies on Abby Williams and Libby German, and key testimony about Libby's cell phone. Thanks for inviting us in. This is our Delphi debrief on WTHR+. In a moment, our legal analyst Katie Jackson-Lindsay will be breaking down the developments for you. But first, senior investigative reporter Bob Siegel and Emily Longnecker spent today in court in Delphi. Bob and Emily, this was a really intense day all the way around, wasn't it?
It was, Scott, and we had another literal front row seat to be able to take in the testimony today. And Emily, this was a tense, it was an emotional, it was a fascinating day of court today, day 5.
Yeah, I would say you listened to more emotional testimony in the morning. I was hearing more of the technical testimony about the cell phone extraction from Libby's phone.
Yeah, very different types. We heard from witnesses today, and we heard really 3 very different types of testimony today. And we want to bring you up to speed on what it is that the jury heard. So let's give you a quick overview of that. Jurors saw very graphic photos as we learned details of the victims' autopsies today. We also got new details about data collected from Libby German's cell phone and a tense courtroom confrontation between a witness and the defense team. Let's begin with the autopsies. The coroner who performed those autopsies the day after Abby and Libby were murdered showed jurors the actual wounds that the girls had. The photos showed one large gaping hole on the side of Abby's neck that severed her jugular vein. Libby had 3 large deep holes that severed both her jugular and 2 carotid arteries. Dr. Roland Kaur explained how that would result in tremendous blood loss, a drop in blood pressure and heart rate, eventually leading to a loss of consciousness, with the girls dying he estimated, within 5 to 10 minutes. He told jurors that he could not be exact as far as a time of death, but he said that the bodies looked consistent during the autopsies with victims who would have died the afternoon before, and that is certainly the timeline of what the state says happened in this case. Other things that we discovered during the autopsy today, Dr. Kaur told jurors there were no outward signs of sexual assault on either of the girls, no signs of defensive wounds to suggest that there was a struggle. He did note during the autopsy very faint lines across Abby's face, and he said that that could suggest that something might have been placed over her mouth, perhaps duct tape, but he was quick to point out there was no residue of duct tape or anything else, so he wasn't really sure about that, but he did point out some lines there. Dr. Kaur said some of the abrasions on Libby's neck could be consistent with the slide on the side of a box cutter that engages the blade, but during cross-examination, he admitted that he did not know if a box cutter was what caused the girls' fatal injuries, and he also said that he could not determine whether there was one sharp instrument or multiple sharp instruments that caused these really graphic wounds. And I've got to tell you, the pictures, they were brutal. They were just brutal to look at in court today. I was sitting right by the jurors, and the juror seated in seat number 6, he barely looked at these photos at all when they were up on the big screen that is inside the courtroom. He really put his head down in his hands like this. His face got bright red. He couldn't bring himself to look at the photos for more than just a quick second or two. He'd glance up and he very quickly would look back down again. This was tough.
I think this is the juror that has consistently done that when we have seen these photos, although many of them have expressed difficulty, but I think he is the one that I note the most.
He's the one who has struggled the most, and we do know from jury selection, he works around kids. He's a transportation supervisor, and he works around kids, and you can just tell this is just gut-wrenching. And some of the jurors are able to stay composed with a stone face, and I can't blame them. I mean,
No.
I found myself turning away at times too.
Same.
And the whole idea here is, this is important evidence. The jurors need to understand what happened and the injuries, how all this played out. But extremely difficult pictures and images for the jury, Scott, to see in the courtroom today.
We're going to get back to you shortly. Our legal expert is in studio with me tonight. This is attorney Katie Jackson-Lindsay. She's with us every night. So what is the importance of showing these autopsy images to this jury?
Well, it goes back to the fact that the state has certain elements they have to prove as it relates to murder. So they have to prove that this was a murder, it was a killing. And so manner and cause of death is really important to that analysis and to proving that element.
And what else might the jurors get from hearing from the pathologist?
So they will also learn the nature of the injuries, the extent of the injuries, and the effect that those injuries would have had on each of the girls. There's been some issues raised through defense questioning about whether the jury should be considering whether they fought back, if there were defensive wounds, if they may have screamed out and others may have heard that. We can see the defense building that storyline, right? So it's important to hear from the pathologist how they would have been affected by these injuries, how quickly they would have sort of succumbed to these injuries, and the overall effect it would have had on their body and their ability to fight back or to scream out.
One other thing that we wanted to talk about, the defense team filed a motion today to admit evidence of Odinism, Norse paganism, ritualistic killing. So previously, as we've been reporting, the judge ruled this information could not be allowed in, but why does the defense think that this motion should be filed now, and do they actually have a chance to get the judge to, change her mind, basically, and allow this in?
Well, based on the reason they have given, the judge should at least consider it. So within our legal rules, there is this concept of opening the door. And what that means is if one party or the other makes a request that certain evidence be kept out, if the other party believes that they've now opened the door to that evidence, it's considered unfair for the offering party to not be able to talk about it. So what the defense has said in their motion is that, Judge, you have ruled that we cannot talk about this as a possible motive, this Odinism religious issue as a possible motive for this killing. But now an expert has taken the stand, or a witness has taken the stand and given a reason for the configuration of these sticks, a reason that we have evidence that supports that there's an alternative theory behind this. And so essentially the state has asked that we not talk about this at all, but they've opened the door to it by eliciting testimony that those sticks were put there in order to conceal the bodies, when we all know from the pretrial motions that were filed that there's a theory that those sticks were put there as some sort of religious representation.
How soon would you guess that we might hear a ruling from the judge on that particular motion?
Well, now that we're in trial, things are moving very quickly. And one thing they noted at the end of their motion was that part of why they're filing this now is because they have to make arrangements for their witnesses to come in. So they have an expert as it relates to the whole Odinism aspect of their defense. And they would presumably have to fly that person in and make arrangements for them. So what they've asked the court is to issue a ruling sooner rather than later.
But that would likely be what the defense brings in once the state rests their case, correct?
Yes, it would certainly call for their expert to come in at
Right.
the point of their case in chief. However, you have to also remember that some of this potential Odinism testimony, they believe they should be able to cross the state's witnesses on.
Some of the witnesses and that kind of thing.
Exactly.
Yep.
So they need an opportunity to do that when the state's witnesses are on the stand.
Yeah, and the investigators, some of the investigators that have been
Exactly,
on the stand.
yes.
Let's get back to Emily Longnecker, who is also in court today, as cell phone evidence came into play, and Emily's in Delphi with Bob right now. So what were the key points from today's testimony?
Well, Scott, this was very dense technical data, really, about cell phone extraction, taking data off of Libby's cell phone. And we learned today that the first time that they did that, tried to get data off her cell phone, was on February 15th, a day after the girls' bodies were discovered. And that was done by a Sergeant Bunner. But technology changes, and cell phones software is updated. And so they have, over the past several years, done more cell phone extractions, one in 2019 and then one again in 2024, this year. And we actually heard from Indiana State Police Sergeant Christopher Cecil about those two extractions that he has done on the phone from 2019 and 2024. And he talked about the data that he extracted that talked about Libby's activities on the phone when she posted to Snapchat that day, taking a video of Abby. And he also analyzed the data that showed when the cell phone was moved. And investigators say the phone stopped moving, we learned, at 2:39 after an elevation change of 20 feet. And we know that the last text that came in to Libby's phone that day was at 4:06, and that was from her grandmother, Becky Patty. And the text said, "You need to call me now," with several exclamation points. Sergeant Cecil drilled in farther on this timeline. He created a timeline from this data extraction. And so we learned, essentially had a roadmap of what was going on that day, some of the posts that Libby was making from her phone. We heard at 1:43, Libby posted that selfie to Snapchat that shows her and Abby in the car on the way to the trail. Abby is in the back seat. If you remember, Libby is in a tie-dye t-shirt. Then at 2:05, Libby posts a Snapchat pic of just the Monon High Bridge, just the bridge itself. At 2:07, we learned that Libby's phone was unlocked by Libby with her fingerprints, and she posts a picture of Abby on the bridge on Snapchat. Now, interestingly enough, and this came up when Sergeant Cecil was cross-examined by the defense, he did not find that photo, that 2:07 p.m. photo. He did not find that on Libby's phone, and he did not find that in the Snapchat cache, the Snapchat storage, when he extracted this data. Then we know at 2:13, Libby records a 43-second video that shows Abby walking on the bridge and someone is behind her. Then at 2:14, we found out that her phone locked, and pretty quickly she tried to unlock it and was unsuccessful. Then we know at 2:39 that phone stopped moving again after that elevation drop of about 20 feet. Again, that Becky Patty text comes into Libby's phone at 4:06 saying, "You need to call me now." And then at 10 p.m., Sergeant Cecil testifies that the phone kind of went into a power saver mode, a hibernation mode, if you will, to preserve what battery was left, but that the phone continued to receive FaceTime calls coming in and iPhone messages from other iPhones coming in, texts. And then at 4:33 a.m., we learned that 15 SMS texts came into that phone at 4:33 a.m. And Sergeant Cecil couldn't explain why. After all of that time, all of a sudden, 4:33 a.m., boom, 15 SMS texts came in. He was asked, could it be possibly because the phone then just connected to a cell tower? And he said yes. And then we know that the phone powered down at 4:34 a.m. We also heard about the movement of the cell phone, the actual movement that they can tell now when they analyze data from a health app. And so at 1:31, that phone started moving, Bob, about 1,600 steps.
It was
they
fascinating,
said.
because they walked us through, and we could see how many steps that Libby took.
Yes.
She was the one
holding
who had
the phone,
at the
presumably,
time.
right?
And you could see, it's amazing now with this
But
technology. And here's the interesting thing is they say that years ago, back in 2017, when they first did the data analysis on these phones, they were not aware
Right.
that this type of technology was even on the phones. They said most people had no idea that there was something called Knowledge C. We're getting really technical
Right.
now. Was this thing that is tracking information on our phones.
Right.
And even investigators didn't know about it back
Right.
then. They learned about it a couple of years later, and then that's when they started doing
Yes.
more extractions
Yes.
on the phones as recently as this year.
Right.
And each time they did an extraction, the first few extra times they did it, they didn't get more information. But
Right.
this year, with more and more updates to this technology,
Yes.
they were able to find out the steps,
Yes.
how many steps the girls took, the elevation changes going up or down.
Right.
Fascinating information that came out in court today.
Yeah, I mean, we know that the phone stopped moving at 2:08 and then started moving again, stopped moving again at 2:18, started moving again 2:25, stops and starts moving at 2:32, and then at 2:39 stops moving completely right after an elevation change of 20 feet, but they couldn't say elevation change up or down.
And one of the questions that you alluded to
Right.
that came at that point, from that moment at 2:39, when the phone stops moving, and there's some text that came in at that point,
Right.
until early the next morning.
Right.
At one point in the evening, around 10 o'clock that night, investigators originally, when they put their reports together,
They thought it shut off.
they thought that the phone had shut down,
Right.
that it was no longer working, that the battery had run out. They
Right.
then revised that report because they later found out
They
that
extracted more technology.
all of these texts
Had
started
come in.
flowing in the next morning,
Right.
and the question was asked to the investigator, explain the lapse in this time, why there was nothing on the phone during that time,
And he
and his answer was,
I can't.
he said, I don't know.
I don't know. I can't. He was also asked in cross-examination if an app tracking movement would have picked up any movement of the phone if it had been in a car. And he said it might pick up if a speed bump was hit. That's when you might know, but that basically when a phone is in a car, you don't know. It doesn't necessarily track that unless you hit a bump. So we heard about that. We also heard for the first time about extractions taken from Richard Allen's devices in November 2022, about a month after he was arrested. They analyzed 26 devices belonging to Richard Allen, and the testimony was, when Sergeant Cecil was questioned by the defense, did you find any information on Richard Allen's 26 devices connecting him to Abby and Libby? He said no. Did you find any information connecting him to the murders? He said no. And then when the prosecution redirected, they asked, okay, but of those 26 devices, was one of them Richard Allen's cell phone from 2017? And no, it was not. So we found out that too.
And Emily, we should point out this testimony they said ahead of time this was going to be really dense. They kept using the word dense for the testimony that the jury was going to hear, and it came at the end, keep in mind, of a very long day of testimony involving these really graphic autopsy photos, and yet Emily, the jury was absolutely captivated by this technical information with these phones.
They did. They had more than 10 questions, and really good questions. They asked about that pic at 2:07 posted by Libby to Snapchat. They asked why was that photo, why couldn't you find that on her phone when it was extracted? Why wasn't it in the Snapchat storage, the Snapchat cache? Sergeant Cecil could not answer that. They asked, could that 2:07 photo showing Abby on the bridge, could it have been posted from another device after logging in to Libby's Snapchat account? And Sergeant Cecil said, yeah, possibly. So he really could not explain why that photo was not on that device in all of the extractions that they have done, that 2:07 photo. So the jury had a lot of questions. It made me wonder, and I haven't gone through all of their bios, but did somebody on that jury, are they a tech head, did they have some kind of deeper knowledge? Because the questions, many of them were so precise.
Yeah, so Scott, again, the jury has really been, give them a lot of credit. They've been taking notes. They have been really paying very close attention. We mentioned the one juror who had to look away during the really graphic photos, but almost without exception, these jurors have been asking questions, sending questions to the judge to be able to ask the witnesses. They've been paying very close attention to the testimony. They are very much engaged in this whole process, Scott.
All right, thanks so much, Bob and Emily. We'll get back to you in a second. Let's bring Katie back in and talk a little bit about the cell phone testimony. Lots of technical information. The jurors seem engaged. What do you make based on seeing the timeline and the extraction information that was pulled from Libby's phone?
Well, it sounds like it was very intriguing testimony, and it honestly sounds like it raised more questions than it gave answers. And having worked on both sides of the aisle, having been a deputy prosecutor, having been a defense attorney. That's really a prosecutor's worst nightmare, but it's also their job. Their job is to put on all of the evidence, put on the truth, regardless of how ugly it may be for them. And I'm sure that they anticipated that this particular testimony would raise more questions than answers. And I'm assuming that they're hoping they'll be able to answer some of those questions down the line.
Does the timeline and some of the extraction information give you any idea of whether or not the phone and the bodies were moved out of that ground zero that we've talked about where the girls were?
Well, I think it definitely opens up that possibility because we have this information now that around 4:30, the phone went into what they thought was completely nothing, right? Nothing happened. And then it went into power save mode around 10 p.m. And so it makes you question where is all of the information in that time frame, obviously, and then where is all of the information in between the 10 p.m. and the 4:30 a.m. And so I think what Emily raised about the expert indicating that if the phone was in a vehicle, we would not know that, that's huge. That's huge. That's an unknown. And that is the epitome of reasonable doubt in terms of whether or not we know those bodies that their life ended right then and there versus at some other location.
And then again, the testimony about the multiple devices that Richard Allen had don't connect Richard Allen to the girls, but as they point out, his phone that he had in 2017 was not extracted, correct?
Right. So I think we have to just accept that evidence doesn't do anything for anyone, right? If it wasn't the phone that he had in 2017, the jury shouldn't charge that to the state and say, well, you presented evidence that those phones show that he, wasn't in that area. Well, those phones aren't even relevant at this point because it's not the phone that he had at the time. So I don't think that's something that the jury should be charging to the state in that instance. But obviously it's something that the defense wants to highlight because it does say you can't put him there through any phone evidence.
Okay, we'll get back with Katie in a moment. Let's get back out to Delphi right now and bring Bob and Emily back in to talk about this confrontation that took place between a witness and attorneys over some questioning about, I presume we're talking about Bridge Guy, right? And what Bridge Guy was wearing according to the witness.
Yeah, Scott, we started the day with testimony from a local resident. Her name is Sarah Carbaugh. She says she's as local as it gets. She's lived around Delphi her whole life. She's incredibly familiar with the Delphi trails and the Monon High Bridge. She says she takes her dogs out there multiple times a week. And on the day of the murders, she was driving her car past the trails when she saw something that really sticks out in her mind. And her testimony was how our day started, and it was an unusual testimony. She testified seeing Bridge Guy, and I'm sure you probably all remember the photo. We can show that to you. The man known as Bridge Guy, that's the person that Libby captured the image of on her cell phone on the day of the murders on the Monon High Bridge. Sarah Carbaugh told the jury that she drove just a few feet away from Bridge Guy later that same afternoon. She testified, she said, I saw a man covered in mud and blood walking on the side of the road. She told jurors she saw him for about 30 seconds. His behavior, she described it as sketchy. And she said that he really stood out because he was wearing a lot of clothes on what was a warm February day. And in her words, she said he was caked so much in mud he had to be right down by the river. When it came time for cross-examination, defense attorney Andrew Baldwin pointed out that her story about Bridge Guy has changed over the years, specifically the part about the mud and the blood. He pointed out in her first interview after the murders, which took place a couple weeks after the murders, while talking to police, Carbaugh mentioned 11 times the man she saw was muddy, but she didn't mention blood at all. During a second interview, she talked 16 times about Bridge Guy being covered in mud, but again, The transcript from that interview has no mention of blood anywhere in that transcript during the interview. And then 2 years later, in 2019, during a third interview, the transcript shows she never mentioned Bridge Guy being muddy. Instead, she said he was bloody, something she talked about 16 times in that interview. Carbaugh denied all that, insisting that her story has never changed. And when the defense attorney asked if she wanted to review her transcript, she reviewed the first transcript and she admitted that even though she thought that maybe one time she mentioned that Bridge Guy was bloody, she looked through the transcript and she acknowledged, okay, I don't see it anywhere in here. And then she insisted, again, second and third interviews, nothing changed, that she reported muddy and bloody. And when Andrew Baldwin, the defense attorney, said, all right, let me show you these transcripts, would you like to review the transcripts from your second and your third interviews with police? She said, nope, I'm good. She really, at that point, got very defensive. And that started this series of really tense exchanges. And I wrote down notes on a couple of them. When Andrew Baldwin continued to bring up this inconsistency that he said in her stories, she looked at him and she said, are we going to do this again? And he looked right back at her and he said, yes, we are. And he continued with that line of questioning, and I think it really highlighted for the jury the potential that her story had changed. Carbaugh, at one point, in talking about these inconsistencies, she said, I saw Bridge Guy walking on the side of the road covered in mud and blood, and that's that. Again, a testy exchange. She didn't want to be questioned anymore about what were potential inconsistencies. And at one point, there was an exchange between Andrew Baldwin and Sarah Carbaugh. She was asked by the jury how far away she was from Bridge Guy when she drove by.
Right.
And her response was she was 3 feet away. Well, when it came time for some cross-examination on that, Andrew Baldwin said, wait a second, when you talked to police, you said that you were 20 feet away. And her response was, well, I didn't have a ruler or a tape measure with me. Who does that when they're driving? It was very tense. And I think, quite honestly, I think her demeanor, I think the questions that Andrew Baldwin was asking on behalf of the defense, they seemed like legitimate questions, and the way she responded, I don't think struck a good note with the jury.
And just in speaking with Bob today, talking about the exchange where she had said he looked like he had fallen down a cliff at one point, that he was so, muddy and tore up, and Andrew Baldwin asked her, well, did you think to stop to help him? Did you think to stop to help him? She said, I'm a female by myself.
Yeah.
I'm not going to stop to help a random guy I don't know.
Yeah, and Scott, I'm really interested, a question to pass along to Katie here. With this witness, and again, there were 3 other witnesses earlier in the week, and they all testified that they saw Bridge Guy. And state police and the prosecutor insist Bridge Guy is the defendant, is Richard Allen. Mm-hmm. So you had 3 people in the courtroom, now 4 with Sarah Carbaugh, 4 people who say on the afternoon of these murders, they saw Bridge Guy, and yet at the defense table, just a few feet in front of all these witnesses,
is Richard Allen.
Is the man that the state says is Bridge Guy, and yet not once have we ever heard the prosecutors ask those witnesses, is the man sitting right there, is that Bridge Guy? And I'm curious to get Katie's take, Scott, about is that good legal strategy? Because I'm wondering if the jury has the same questions that I do, why they wouldn't be doing that.
Yeah, that is a really good point. So let's ask Katie that. Why wouldn't you ask these witnesses, hey, is the guy that you saw that day Richard Allen sitting right here? Why wouldn't you ask that?
As a trial lawyer, one of the first things you learn in law school is you do not ask a question that you do not know the answer to. And what we've learned about this last witness in particular is that she was really unpredictable. She was really what trial attorneys would consider a wild card as a witness, and her credibility was at issue. So it could be for the state that they're not really sure how she would answer it. It could be because she's answered that question in different ways before. But from a true legal technical standpoint, it could be that the defense could raise the argument that any identification that she would make at this point would be suggestive because Richard Allen's face has been plastered all over the media. And so it's hard to tell which of those it is, but it's important to highlight that neither side asked that question. And both sides would have done pretrial discovery to the extent that they should know what her answer should be at this point. And the fact that both sides stayed away from that question, I think is pretty curious, and it had to be a part of strategy.
Well, it would make sense that if the defense thinks that the witnesses are going to say, yeah, that was Richard Allen, they wouldn't ask. But if they thought that, oh no, they're going to point to someone else, why wouldn't the defense jump in and ask?
Well, that's exactly why I go back to this witness is a wild card. She is any party's worst nightmare. She has given inconsistent statements about something that's so important as a muddy and bloody guy on the bridge that day.
Right.
And so if you just pay attention to the sheer amount of time that was spent with her, the state treated her in a way that it was clear that they wanted to get the information they needed, get her on the stand, and get her out of there. And I think that says a lot about a witness who has information that's so significant to this trial in terms of seeing a bloody guy out there that day. And it appears that the defense tried to do that too, but she was willing to spar with them a little bit. And you never want that to happen as a defense attorney. You don't want the jury to think you're beating up on a witness, especially a local civilian who's just here to tell her truth. So with that kind of witness, you have to be very careful. And if they're unpredictable in what they might say, or if she's given inconsistent testimony as to whether or not that person looks like Richard Allen, it's safer for either side just to not deal with it.
Okay, so that rules out this witness that we're talking about. What about the other three?
That's a great question.
Why not ask these three? Hey, is the guy that you saw on the trail that day the defendant, Richard Allen?
Well, what we know is that the state should have been the party to ask that specific question, right? It's the state's burden to prove in those elements we keep going back to in terms of proving murder. They have to prove that Richard Allen, the defendant, committed these crimes. And so the onus would have been on the state to prove identity at that moment and make an in-court identification. And so the defense handled that exactly the way that they should. They raised questions about the build, the height, the weight, the hair of each of those individuals, the age, and they really highlighted that it was inconsistent with Richard Allen. And so that gives them an opportunity to follow up later on that without having to have the witness explain why they couldn't answer whether it was Richard Allen or run the risk of them saying, yes, in fact, now I think it was.
Yeah, so we are 5 days through this Delphi murders trial. It has been so interesting. We're going to be here every night breaking this down, 10 o'clock right here on WTHR+. You can also find our ongoing coverage, including detailed reports of each day of the trial. Just go to WTHR.com/Delphi. Thanks for joining us.